Terminated the charges against one of the accused persons in this NHIF case or NHIF related cases. That is number 48 of 2018. The person whose charges have been terminated is called Geoffrey Mwangi or Jeff Mwangi. He was the General Manager Finance at the time when this tender was awarded, and later on he acted as the CEO of NHIF from 2018 until the time when this case was filed in court. Of course, then he was suspended. Before Jeff Mwangi's case was terminated, the DPP had actually terminated the case against the service provider because the entire case relates to award of some tender on provision of services relating to collection of revenue. So there was the integrated revenue collection services, which was being provided by a private limited company known as Jambo Pay. Jambo Pay bid for that tender competitively, it won it, and it provided services. It collected in excess of 80 billion on behalf of NHIF. It was being paid commissions from the collection. So Jambo Pay was not being paid commissions by NHIF from public money. It was just the commission of money that was raising. Yeah? So when we went to court, I acted for Jambo Pay in that matter. We went to court, questioned why the service provider had been charged along the staff at NHIF without showing a connection of influence or improper contact with NHIF staff that awarded the tender. So later on we applied for review and the DPP terminated the charges. It's important to note the charges against the Jambo Pay were not terminated in court, they were terminated by the DPP. Also, just like that case, the charges against Jeff Mwangi was terminated on invitation by Jeff Mwangi, who wrote to the DPP requesting the DPP to review the charges against him. The Constitution at Article 156, sub-Article 4, 5 and 6, allows the DPP to review charges against anyone and terminate them and even discontinue, because the power to institute, continue and discontinue with charges reposed with the DPP. So there's nothing political. I think that's the point in review and termination of charges. It is a purely legal procedure. The DPP charges on the basis that he has good grounds to charge, and you cannot fault the DPP for commencing charges against someone. But the DPP can also review those charges because the Constitution creates a legal framework for review of charges, be they corruption or ordinary criminal cases. He can review on his own, or he can review on invitation by the accused person. In this particular instance, the accused person was the former NHIF CEO, Jeff Mwangi, wrote to the DPP and requested the DPP to review those charges. The DPP re-evaluated the evidence and found that the evidence could not sustain the prosecution and sought to terminate. When he moved the court to terminate the charges, the court asked, should I terminate the charges only against Jeff Mwangi or against the other accused persons as well? So the purpose of today's ruling was to evaluate whether that termination would also extend to the other accused persons. The charge sheet has 18 accused persons. So one has left, so 3 left. There are 21 accused persons. 3 left, directors of Jambo Pay and Jambo Pay. Then we remained with 18, and now 1 has left. So what the court has directed is that based on the DPP's own application, that they need 15 days to review the entire file. They will then review the file and then make a decision whether more termination to follow. So yes, we can expect there's a possibility that the DPP will terminate more charges against the remaining accused persons. So basically that is the overview. Unless you have a question.
When are the dates?
Sorry. Anything else? So just a quick summary. Charges, when it comes to termination of charges is pursuant to the law. And I think that is what we would like the media to understand. Because questions, when the news starts running, question will emerge, is the DPP responding to public pressure? Corruption cases are being terminated. I think we've seen that misrepresentation, but people who are in court, like court reporters like yourself, you've seen the ruling. You've heard the ruling. The ruling says, under Article 156, the DPP has the power to discontinue those charges if evidence shows that there's not enough evidence to continue with the charges. And that is also anchored by Article 157, sub-Article 11. So it's a purely legal argument as opposed to a political conversation or a political response to the realities of the day. And more termination will happen, as it has already been the practice previously, like Jamboke's case in this particular case was terminated on 8th of June 2020. On 8th of June 2020, when the DPP was terminating the charges against Jamboke, in this particular case, there was no conversation around political influence. So it's important to get the right context and the right reasons for termination. If we make comments that make it impossible for the DPP to review files, for instance, if the DPP reviews a file, pursuant the law, and terminates, and people start politicizing the termination, it can demoralize the office. But also what we must also recognize, that when the termination happens, it means the person who was in court actually ought not to have been charged to begin with. That is the bottom line. That they ought not to have been charged to begin with, only that we cannot blame the DPP for preferring those charges, because at the time when the DPP was preferring the charges, he had reason to believe what lawyers call the existence of prima facie evidence that could sustain the charges. I think that's all.
The need to have the same. Now, I've considered the application, and under Article 157(6), the DPP has powers to institute and undertake criminal proceedings against any person before any court of law. He also has powers to terminate the charges at any point in time for reasons that he may deem fit. The power to discontinue a matter, again, is donated under Article 157(6)(c) of the Constitution, and it's subject to permission of the court under Article 157(11). Those powers are to be exercised with regard to public interest and the interest of administration of justice, more particularly the need to prevent and avoid abuse of legal process. I do not wish to revisit the reasons I gave for while accepting a withdrawal in CR number 15 of 2021. I adapt the same grounds and I adapt the ruling as if it were part of this particular case. Consequently, in this matter, I find that sufficient grounds have been laid in support of the application, and I therefore allow the case against accused number 2 to be withdrawn under Section 87A of the Criminal Procedure Code. But again, I still insist, and as the prosecution has conceded, there is need to review this entire matter. I am now giving the prosecution 15 days to review the entire file and come up with the way forward. So, sureties for accused number 2 discharged. Cash bail, if any surety is discharged, if there's any cash bail, it should be refunded to the depositor. We can take a mention convenient to all.
Most of that, Your Honor.
Maybe I prefer. Do you have them? Or you have taken me saying that?